Session Chairman Naginji, Prashanth, Madam, and ladies and gentlemen, Archana Madam, and ladies and gentlemen. So today we are here to discuss, as Prashanth was mentioning, about the search and seizure, and I thought of touching upon the data privacy laws, so that how this data privacy laws are impacting the search and seizure. In fact, if you were to look at, friends, every day, starting from when we wake up early in the morning, so we go on a walk, possibly we have a watch which counts how many steps we have walked, and then possibly we come home, we want to go to office, and we hire a Uber, go to office, and in the afternoon we have to lunch we have to order. There are apps which Uber Eats apps are there to order lunch, and then evening we have to go to a movie. We have Book My Show, and then groceries at home. You have digital apps which gives you all the services. If you look at in each one of these cases, what you have given is your phone number and your email ID. And just imagine the digital footprints that we leave behind in all these cases. And at the end of the day, at the end of the year, we have to file the income tax return. And while filing the income tax return, still, when it comes to drawings, we go by estimate basis. Based on a particular person's estimate, the lifestyle, we go on an estimate basis. So, in fact, gone are the days where the income tax department knows about you, about your clients, more than what you do about yourself. So that is what is the power of this data that we have. While data is very powerful, no doubt, but the responsibility that comes along with data is still humongous. When we are looking at, how this data protection, laws have evolved, it is quite interesting to see. In 1956, there was first case of MP Sharma. It was a very interesting case where they said, it was a Supreme Court decision for that matter, it was held that data, is right to privacy is not a fundamental right at all. That was what was held. It was right to privacy was not a fundamental law, is how the law started in 1956. In 1962, UP High Court, it gives a very interesting decision which says that in that particular case, majority decision was that privacy right was denied by majority of them, and only minority of them upheld privacy as a right. To MP High Court subsequently recognizes this common law principle of data privacy, and then for the first time, in case of Tamil Nadu, Madras High Court, it links the data privacy to Article 21. Thereafter, we have Puttaswamy's case, we have, Information Technology Act, and there came DPDP Act, Data Privacy Protection Act. So, in fact, if you look at all these things, it's quite interesting to see how the data privacy has evolved within Indian legal framework. Having said that, so the challenge today what we have is how is that this data is being processed. See, as I said, every step we are leaving a digital footprint. So just by having our phone number, is it possible for an officer to go behind and get entire 360-degree profiling of any of the assessees? Practically possible, but then is it possible by law? May not be. So that is where the question of our data protection comes into picture. That is why the awareness of this data privacy laws that comes into picture. For example, if you look at, very interestingly, Section 148, 147, 148 had a clause which said a reason to believe. You know, assessing officer ought to have reason to believe for him to initiate this 147. That was the law. But then now it has been amended and the reason to believe has been done away with. And they have come up with a new paradigm where they say digital strategies are being envisaged by the CBDT, and based on that digital strategy, whatever is flagged off, that those are the things that are taken up for scrutiny or 147. Now look at a situation. I mean, I'm just giving an example where when you take out the reason to believe out of it, that means you are taking out human intelligence out of it. So reason to believe, you need to have a human intelligence. If you take out the human intelligence, if it is going to be only risk parameters that are going to, that means you are feeding algorithms, you are feeding data into algorithms. You are feeding data into algorithms, and what algorithms flag, that is what is going to be picked up for 147 reassessment. And when 147, these are possibly looks like sometimes hypothetical, but then this is what is going to be there for us in future. So that is why I thought I'll just flag these things for your kind consideration. Let us look at a situation where you have a 147 notice issued, and let's take an example of, commonly that happens with, let's say, real estate agents or a doctor. A 147 is issued, and then a doctor has been told to provide books of accounts, patient records, and his bank statements, everything. So possibly under 142.1, he provides all the information except patient records. Except for patient records, because he says patient records are confidential, so therefore I will not share, because that is what is taught to him in his medical school. So look at now, if it is a human, if there is no human intervention, where entire thing is being done by machines, just because this doctor has not provided this patient records, there is a violation of 142.1. 142.1 is not complied with. So therefore, can it become a reason for a search? Because one of the reasons for a search is 142.1 not complied with. Now, if there is no human element, now a situation like this gets flagged. For example, let us say a genuine case of, let's say, real estate agent, real estate developer. So he has been asked to provide all his books of accounts, contracts, etc., agreements, everything. So he probably provides books of accounts and part of the agreements, he says it is there with his advocates, which are any day these things are possibilities, right? So he may say that it is there with advocates. And so therefore, if it is to be done by a machine, again there is a violation of 142.1. So can it therefore trigger a search on these accounts? Is something very interesting phenomena that we have to look at it. While we are looking at it as an interesting phenomena in India, is it something that has happened elsewhere in the world? The answer is emphatic yes. The situations in some of the countries are so challenging that in Dutch, the government had to step down because of this. In fact, they had gone on for giving some sort of incentives to their underprivileged people there in that particular country, and they felt that it has not been utilized properly, and therefore a system was integrated into it to find out people who have misutilized this. Unfortunately, what happened was it picked up people from a particular area. It picked up people from a particular area which was there, most of them were immigrants. And so therefore a huge chaos that broke out, that how can this particular thing happen, that particular area, people from immigrant only were, only were picked up. So they went on to identify and understand that the data, that the machine learning, the machine algorithms that were there, the information that were fed into that there were a human biases into that, the information that was fed into it. And there was an embarrassment for the government. They had to go for a huge amount of payments and reimbursements. And in fact, a government had to step down within, even just few months before their term ends, they had to step in because people went on to the streets. In fact, very interesting case that, another case that we have in this particular case is that this is again in case of a Dutch, one of our countries, 17 different agencies were feeding the data to a system. 17 different agencies were feeding the data into a system. And out of that system, information were flagged and notices were sent. And automatic notices were being sent to them. And they did not know why these notices are coming. And they had absolutely no clue as whatsoever, not only the people receiving the notices, but also the officers who were sending it. In fact, the machine was sending it, so therefore the officers were also clueless as to why it was being sent. So this is something, in fact, this went on to this entire system, European Convention on Human Rights, in Hague, they held this entire system as a violation of privacy, and in fact, it was struck down, that particular thing was struck down. And so like this, if you look at, I can give you many examples on these aspects. In fact, something on these lines happened even in Australia. In Australia, if you look at, again, some incentives, some benefits were given to people who are, who had certain below average income strata, and certain benefits were given to them. And at some point in time, the machine that, their system, they triggered certain red flags saying that, so many people had to refund that money. And then again, the notices went to them to refund that money, and again, chaos broke out. And then finally, when it was understood, what had happened was the people who had to claim the benefit had to lodge their income details to a particular database. And that database was compared to that of the income tax database. And while the database where they fed, there they took the average of 26 weeks, whereas in income tax it was 52 weeks data. And the assumption that had gone wrong here was, when they were flagging these things, they took 52 weeks data average, but then here 26 weeks, when somebody had earned more, they were asked to pay back, because the fundamental assumption was that all people were earning it in average on a same to same every month, was a assumption that was made in this particular thing. Like this, has it been happening world over? These things, there are many examples of this. So therefore, what is that we have to be aware of? We are representing our clients, and we have to be, aware of what are the provisions that are there. Only to the machines. The question is, nobody can say why it was selected. It becomes a black box. It becomes a black box to an extent that that nobody will question the outcome of it. And when you don't question the outcome of it, you tend to accept what that black box says or the output that it gives. It's a situation which, as I said, has been happening now for in many of the countries. And so therefore, the question that is important for us to understand, together with the government, you and as I institute, when they say data strategy, that's the data strategy that gets into the system. What is that data strategy? What data is being fed into it? At least that clarity we must have. Because what data is fed into it, it is something like those machines are ego machines. Garbage in, garbage out. What data goes into it is very important for us to understand. Then how is algorithm trained? How is those things, algorithms are reading those data and how are they getting trained? And is there any human validation is there? If that entire thing is being done by machines, is there any human validations is there? Is there any discretion for human beings to override it? These are some of the fundamental questions that we have to ask when we are looking at a situation where department today is way ahead of us and the corporates as far as the data is concerned. They have, as I said, with single phone number or your email ID, entire 360-degree profiling can be done to an extent. It is possible for, in one of the case we received a notice wherein we were perplexed what has gone wrong with that particular person, because his entire system, when we had looked into his income tax returns and his books of accounts, there seemed to be no red flags. But when we started representing the matter, we came to know that this gentleman he was going to US often. So if his US trip used to be something like this, from here to Dubai economy, Dubai to Bangalore economy, but then Dubai to US back to Dubai was in first class. So the question is, now department is empowered even to get this data, exchange of information. They are empowered with these kind of information at their hands, right? So as Prashanth was also mentioning about, gone are the days where search, when you look at, the search was predominantly for looking into your books of accounts, records. These were the days. Gone are those days. Today, the assets are there digitally, virtual digital assets. So therefore, there have been instances now when they ingress into you, it is not only breaking open the doors, breaking open the locks, but also they can override and take over those codes, your passwords, and they get into your digital communications, your emails, your banking transactions, your remote storages, your social platforms, your crypto assets. These things they can look into it, right? While they can look into these things, is it that this right can be given disproportionately? Because there are possibility that they, right now as it stands, is that they can look into any of these things. If you look at any of the social media or our digital storage assets, there is an end to this. Because this access, unlimited access, also violates the proportionality principle that was envisaged by the Supreme Court in Puttaswamy's case. There has to be a proportionality. It is not that there has to be, you cannot, what is proportionality? You cannot collect excess amount of data. You cannot process excess amount of data. You cannot retain excess amount of data. This is the proportionality, right? So if that is the case, if ingress is given to the department in matters of all these assets, virtual assets, where is an end to it? You may ask, why is that end is required? The end is required very much because in one of our search matters, when generally what happens in search, after search, post search proceedings, the first question, first letter we send, all of us as practicing chartered accountants, we send to the department is to provide all the copies of all the seized records and digital assets. In fact, we did that. In one of our recent cases, we did that. We asked for physical records, copies of the physical records, digital records. But as we were copying it, we came to know that it is going to be very dangerous to take these digital assets. The reason was very simple. The client, where it was searched, there were certain video clips which he was in a compromising position with some of the leading actresses of this cinema. So just imagine if we were to copy those things, and if it gets into some wrong hands, what could happen? And so therefore, by the way, what is the use for the department to use that particular data? In fact, department would be interested in looking into the financial transaction. They might not be interested into looking into these aspects, right? So where is the limit up to which we can, department has to be given the right for accessing this information. So this is something which is currently not there. If you look at as evolved economies, other economies, whether it is OECD or US, they have clearly laid out the principles of this proportionality. You cannot, even GDPR for that matter, the principle of proportionality is there. But when you look at income tax, while our data protection law, it is there, but when you carve out an exception is carved out in case of a data protection law, so that a right can be given to the income tax department in the guise of national security. They can ingress upon you and your digital assets. So while doing that, while the right has been given by way of carving out an exception, but there is no accountability that has been put in the Income Tax Act as far as officers are concerned. If they ingress into that, your personal, beyond a certain, for example, health records, what they have got to do with the health records? But then using that health records, again, therefore, the question that comes up in these kind of a data privacy issues are, to what extent, what is that ethical dilemma that one has? What is the limit up to beyond which they cannot cross that ethical dilemma? For that matter, in again one of the case, there was a health record that was made up, that was available because it was a digital asset. Health record was there of SSE's wife. The person who was being searched, his wife, and department came to know that she is mentally suffering. She has got some mental illness. And therefore, always husband has to be there with her. Otherwise, whatever that mental ailment that she had to undergo. But now, department, at some point in time, in using this particular information, were able to extract, statement from that SSE. Now, the question is, where is that ethical, where is the line beyond which you cannot cross? These are some of the things that comes into picture as far as this data privacies are concerned. So, in fact, friends, on these things, in fact, if you look at, as I said, many of the cases that are, many of the cases that are there. So just I thought I'll take a few of them from Indian context. Let us look into Indian context, what has happened. In fact, the very fact that Puttaswamy case went up to Supreme Court was that, while you can link PAN and Aadhaar, you cannot have access to, biometric data. The law of proportionality. Only in respect of Aadhaar, the matter went up to Supreme Court, and a law has been laid out as to making this a fundamental right under Article 21 of the Constitution. Now, if you look at recently, vegetable vendor in Karnataka was slapped with 29 lakhs of GST. Now, where was that information coming from? Because it was coming to them from, UPI transactions. So possibly that UPI transaction triggered that it has crossed, his collections were more than 20 lakh rupees, and so therefore it triggered that particular notice. But fundamentally, if you look at that particular transaction, because they are vegetable vendors, fresh vegetable vendors, it is GST exempt, right? How did it then, the notices went? Possibly the system what was developed is developed to say that if wherever UPI transactions are more than 20 lakh rupees, send notices without even human intervention. If there was a human intervention, they would have understood, analyzed, stating that, it is tax exempt transaction, so therefore notices need not be sent. Same is the case that happened with Pani Puri Walas in Tamil Nadu. Right? A notice has been sent to them, and people have come onto the streets. And exactly what I was referring to in other countries, similar pattern you can see happening out here, right? So therefore, if you look at the sensitivity of data, you know, these are sensitivity of data or algorithmic biases or lack of transparency, no human oversight or data security gaps. These are some of the challenges that I see as far as this data privacy is concerned vis-a-vis our income tax. So these are some of the things I thought. In fact, the exact replica of income tax matter, if you were to look at it in US, it happened that there was a finding by IRS that black taxpayers are likely to be audited. When we say audit, it is sort of a scrutiny there. They are likely to be audited 3 times to 5 times more than other people. So this is the bias that has crept in. This is IRS's own finding. So considering these things, we have to be, careful of, our data handling and where we have to provide the data, where the consent has to be given. These are some of the things that we have to keep in mind. And also another one important aspect that we have to bear in mind for us as well as for our clients is that we have this softwares which file the income tax returns for a much cheaper cost. They file the income tax return. So people do not want to come to chartered accountants because there is an app which files their income tax return. They say, right, there is no free lunch. In fact, Google is also free, but then you know how they monetize the information, the Google search results, how they monetize it, right? So if an app is filing your returns for free, if an app is filing your income tax return for a very low cost, let's say 100 rupees or 200 rupees, whatever it is it that it is doing free? Is it that it is doing a social cause? No, not at all. In fact, similar thing happened in US in Pixel Hunt project, wherein an app like this in US was filing, it was filing their returns for free. What it was doing internally was that the data it used to collect, so as a assessees, we feed our clients' data into it, we feed our data into it. It is a third-party software. That third-party software relays the data to the income tax department. In between, they have access to our data. It is a gold mine for them. In fact, one of the promoters, one of the CEOs of April Software, if you go and Google it on this thing, you will find April Software. He went on record to say that, while making his pitch for the April, that software, while making a pitch, he went on to say, every year there is $3 billion of refund that is being claimed by taxpayers in US. $3 billion. So he said, this $3 billion data, if I were to sell it to banks can send them a targeted messages to say that you are getting a refund, you put deposit in my. Where is an end to all these things? Right? So therefore, friends, before I conclude, I thought there are certain thoughts I had in my mind, so I thought I'll just share it with you before I conclude it. So, while data, is it, therefore, data privacy, no doubt a concern. But digitization, yes, we must accept it. No doubt we must accept this digitization. But then we must accept with a sort of, safe guardrails. What are those guardrails is what I thought. I'll just share it with you. One is, while income tax department gets into our data, as I said, limitlessly it gets into the data. Can we set some limits? So they need financial data, right? Can we access it only to financial data and not to other data? So currently, is this the practice prevalent in other jurisdictions? Yes, it is prevalent in other jurisdictions. Can we follow those things? Can we study those things and adopt here? Is one thought I thought. Second, see, data privacy, there is a board, separate board for data protection. This entire data protection out of this, a part of it is carved out and a power is being given to the income tax department. So therefore, while the power has been given, can we also give them the responsibility? If somebody misutilizes it, can he be penalized there? So that there is an awareness, even for the department, yeah, this data and it has to be used carefully. Right? And then, again, if you look at those, as I said, digital data, you have so many digital data, so many contents that are there. Do we have any audit trails of what all the content they have looked into? They are supposed to look into only those financial data. Why do they have to look into other data? Can we have an audit trail of department which all the files they have looked into? And it also gives how long they were there in that. So can we really have these kind of, and of course, the cyber security. This entire, our financial data is a very sensitive data. And this financial data is sitting in a server and it is a honeypot for hackers. And it is there for many more years. It is not for a couple of months, it is there for years together. So it is a honeypot for hackers. So what are the safeguards? What are the guardrails that are there for this? And then as the tax laws have been evolving and the new sort of code that is emerging for the income tax department as far as this getting into this virtual spaces. So can we have, as assessees, can we have a digital rights as well? While the rights and duties have been there for time immemorial, which is there, can we refine those digital rights? Can we have those new digital rights which protects our interest? Friends, these are some of the thoughts I thought I'll share it with you. Thank you so much.
Present before you, CA Prashanth GS, sir.
Good afternoon all. At the outset, I thank the Bangalore branch for having given me this opportunity to share my views on search and block assessment and data privacy. We are indebted to our parents for life. We are indebted to our guru for the way we live. I take this opportunity to place on record my deep sense of respect and gratitude to my mentor, CAS Venkatramani, who has been a guiding force and factor in my endeavor of profession. Also, my deep respects to CAD Devraj and CAA Shankar, who mentored me at various stages of my professional career, which has enabled me to present before this august gathering. To stay beside and set the tone down, but for Nagin sir's guidance in the initial years of practice as to how to read Section 132 and what search is all about, probably I wouldn't have been here speaking in a session where Nagin sir is the chairman. Thank you, sir, for all the guidance for so many years. You're blessed. And I also can say that we have learned search and seizure and block assessment at Nagin sir's feet, and it wouldn't be an understatement. Thank you, sir. These terms, search, has got a lot of ramifications, but has it been even defined in the Income Tax Act? The word has not been defined. Was search provisions part of the original 1922 Act? In fact, no. It came in much later. But how search has evolved from after the introduction in 1922 Act to 1961 Act, and how it has held on to the fort even in the Income Tax Act 2025 now, which has received the presidential assent also now. We have to look into various facets of it as to what is a search is and what happens in a search. Considering that we have about 40 minutes to deal with it, I would not go in accordance with the presentation which is given, but based on the guidance that Nagin sir gave on what aspects I should cover first. We will talk about the constitutional test of it first, saying whether conducting a search violates the doctrine of arbitrariness. Because as per Article 14 of the Constitution, which has given the right to equality, whether a particular law or an activity undertaken by a law enforcement agency, we have to look at it whether it passes the doctrine of arbitrariness. To say, why do we say it is arbitrary? Or why should we say that it passes the doctrine of arbitrariness is that any statute which imposes reasonable restrictions on fundamental rights, right to privacy, right to hold and enjoy property, right to carry on profession or trade, we have to see whether it manifests this doctrine or not. And we had various courts dealing with this particular proposition to say how it passes the constitutionality test. You will have one fundamental right about the violation of fundamental rights in search. Whether when a person ingresses into your property, is there a violation of your fundamental rights, which are the basic human rights as per part 3 of Articles 12 to 35 of the Constitution. We also have to look at violation of right to privacy as per Article 21 of the Constitution, where it talks about right to life and personal liberty. In the famous judgment of Union of India versus K.S. Puttaswamy, this is Aadhaar judgment, it spoke about how right to privacy would pass the rigors of fundamental rights, and it passes the rigors of being a part and parcel of Article 21. So considering how the data privacy laws have come in and how Article 21 has been interpreted to say right to privacy is a fundamental right. You also have, earlier you had 19(1)(f) of the Constitution dealing with right to hold and enjoy property, which was a fundamental right, which means acquisition of properties could not have happened because a person had absolute right over it in terms of Article 19(1)(f) of the Constitution. By the Constitution Amendment in 1979, Article 19(1)(f) was removed and Article 300A was inserted, which has got reasonable restrictions that when you hold your property, but by authority of law, it can be acquired. So the fundamental rights and the constitutional test have gone on different facets. You also have one important article, Article 20, subclause 3, that is protection against self-incrimination. What is this self-incrimination? You are not expected to give a statement which is going to harm your self-interest. You cannot be compelled to make that statement. That is the protection against self-incrimination provided in Article 20, subclause 3 of the Constitution. Be that as it may, now when we look at the search, Section 132 of the Income Tax Act 1961, and now in the Income Tax Act 2025, which will come in from 1/4/2026, Section 247 deal with the search. The important contents we have to digest in terms of the terminologies used in search are reason to believe, reason to suspect. Why is this term reason to believe so important? Because we've had 147, that is a reassessment, and reason to believe, and probably we can speak about it for a day as to what is reason to believe and how it differs from reason to suspect. But the important facet in 132 is about the authorizing officer must have information in his possession that he has reason to believe that a person to whom a summons was issued under 131, he will fail to produce the requisite books, or a 142(1) might be issued that, and he might not produce the books of accounts. When the act is used, might be issued, and he would not produce, there comes in the element of reason to suspect. And you also have a person who is in possession of money, bullion, jewelry or article, and it represents wholly or partly income or property which has not been or would not be disclosed for the purpose of the act, which means there is an apprehension on part of the legislature that certain transactions would not be disclosed but for the action of search under 132 of the Income Tax Act. Now, where do you get this term information from? What is information? Is it defined under the Income Tax Act, or do we fall back upon the judicial pronouncements to understand the term information? The expression information must be something more than a mere rumor or gossip. It must be a material which must be regarded as information which must exist on the file, which means it must be tangible in nature. It has to be based on evidence, and it cannot be based on mere rumor or gossips. So therefore, what we come across in the public domain as to how a search was conducted and how the officers would come into your premises, destroy your furniture, rampage your houses, this really will not hold good practically as to how it happens. Therefore, we have to look at it from what is the term reason to believe and how does the authorizing officer have the reason to believe. Again, reason to believe in terms of income tax, we've had from Narayanappa's case to Shivanath Singh to the judicial treatise on that is large enough. But Bharatiya Nyaya Sanhita 2023, section 2, subsection 29, defines the term reason to believe by saying a person is said to have reason to believe a thing if he has sufficient cause to believe that thing but not otherwise. So therefore, somewhere it is the independent application of mind on part of the authorizing officer as to what information he has got in his possession for him to authorize a search to the officers subordinate to him. You also have 132(1)(a) talking about reason to suspect. Why should reason to suspect form the fulcrum of search? Because if people do not ordinarily disclose the transactions that ought to be disclosed in a particular way or a particular fashion, department has no way but to ingress on a premises and conduct the search and seizure operation. But you have to also look at the different facets which come in. As I told you about reason to believe and reason to suspect, the most important ingredient in search should be the authorization, wherein the powers are on the authorizing officer, which is generally at the highest ranked officers in the department, the principal director of income tax investigation, or the chief commissioner, or as the case may be, who will authorize the officers subordinate to them to conduct the search. So what happens in case of, and what are the issues that may arise during the authorization? Can business premises be sealed just because they have come for a search? Can a search warrant be issued indiscriminately? When we talk about warrant and the information that the officer has got in his possession, it leads us to a situation where how do you know what was the reason to believe that the officer had got in his possession before he authorized the search? This led to litigation, and Karnataka High Court in the case of Ramai Reddy, 339 ITR 210, argued by my senior Mr. Shankar sir, wherein the Karnataka High Court brought out that when you talk about search, the reason to believe or the reasons as recorded by the Income Tax Authority has to be provided to the appellate authorities. It was a matter dealing with the erstwhile block assessment regime, now which has come back in a different avatar now. So in that context, Karnataka High Court held that the reason to believe or the reasons recorded for conducting the search can be looked into by the appellate authorities, which means either the Income Tax Tribunal or in fact including the Commissioner of Income Tax Appeals had got the power to look into the validity of search as to whether the authorizing officer had applied his mind independently with proper information on record to authorize a search. The information being provided to the tribunal would not have caused a lot of distress, but the information when called for by the Commissioner of Income Tax Appeals had an administrative anarchy set in that, because the Commissioner of Income Tax Appeals, though a quasi-judicial authority, sits in 3 or 4 ranks below the authorizing officer, which happens to be the principal director of income tax investigation, which means the Commissioner of Income Tax Appeals, a lower ranked officer, has to sit in judgment as to whether his boss, that is the principal director of income tax investigation, has applied his mind properly or not while issuing a search warrant. And the matter was pending at various stages, at which point in time in 2017, the law was amended with retrospective effect to say the reason to believe or reason to suspect, as the case may be, will not be provided to any authority, any income tax authority, including the Income Tax Appellate Tribunal, thereby shutting the doors on the assessees seeking recourse to the mind of the authorizing officer as to whether he has applied his mind in authorizing a search properly. But does that really take away the right of the assessee in not seeking for it? Because the terminology used there was reasons as recorded by the authority need not be given. So different facets of search, right from warrant, whether the warrant was signed, whether it was issued in joint names, whether it was for the premises, whether it was for the person, those issues also can be looked into. Now take a situation where they have conducted a search and you challenge that particular search action as arbitrary, violation of rights in a writ petition before the High Court or SLP before the Supreme Court. And assuming that the search is held to be illegal, even then, the documents that have been found and seized and the information in the documents found in an illegal search also can be used against the assessee in any subsequent proceeding. So therefore, at the first cut, even if the search is held to be illegal, that particular documents which would have come to the position of the officers during that search, which has been subsequently termed illegal, can be and will definitely be used against the assessees in the subsequent proceedings. And the law relating to this, Supreme Court way back in Puranmal's case, 93 ITR 505 said that documents found in an illegal search can be used for subsequent proceedings. So what happens? We generally hear about confessionary statements being obtained during search, that so-and-so admitted to income during the search. So what happens during a search? Once the officer has come, they record statements on oath, so that for giving a false statement on oath, you can be prosecuted separately for that. It comes to a position as to what are the rights of the assessee, the duties, obligations and rights. The taxpayers charter also given by the CBDT in 208 ITR also talks about the right of searching the officers who enter your premises. You can undertake the search of the officers before they enter the premises because evidence cannot be and should not be planted, especially now in the present digital era. In the days of manual ledgers and documents, planting of evidence might not have been very easy, but in the digital era, and the presumption in search is that under 132(4)(a), any documents, information found in the premises is deemed to be yours, and the presumption is rebuttable, but you are supposed to make effort to rebut it that particular information does not belong to you. So you can undertake the search of the officers coming in there. You have a right to say that the women of the house would be searched only by the women officers. And due to any customs or traditions, if the women of the house do not come out, or they're known as the Pardanashi women, they can be protected and they need not come out during the proceedings of the search also. School children must be permitted to attend schools during the day. Of course, their school bags also can be checked, but they have to be permitted to go to school. The taxpayers' charter is well defined. But what happens practically during search and what happens due to the confessionary statements? Can they obtain confessionary statements? The answer is a blanket no. But what is this terminology that we have heard for so long? Admission during search. That on oath during the search, a statement under 132(4) is recorded wherein the assessee admits to certain transactions which has not formed part of his books of accounts, or in other words, he agrees to offer additional undisclosed income for taxation. But is the admission sacrosanct? Once he has made a statement on oath that he agrees to offer a particular sum as additional undisclosed income during search, is it final? Is it fatal to him that once he has agreed on oath, signed the statement, and also given a confirmatory statement a week or a fortnight later stating that his earlier statement still holds good? What happens to this particular admission, and what is the evidentiary value this particular this evidence or the statement by the assessee has got? To look at it during the course of assessment, when the assessing officer has to apply his mind independently to the seized material, and also coupled with the fact that the assessee is admitted to undisclosed income. The important facet here is, just because the assessee is admitted to a particular undisclosed income does not give the right to the officer to make additions on the same count without independently forming an inference of liability based on the seized materials or other books of accounts which are in the possession of the assessee, which means it necessarily must be led by an evidence, a mere statement that I agree to offer 100 crores as undisclosed income does not give the right to the officer to make the assessment solely based on the statement made. So what happens? What is the issue when it comes to the evidentiary value of this, and how will the department treat it? I'm sure in most cases, department would not go back on that. Despite the fact that there is no evidence to prove your admission was right or wrong, department will hold its fort and say, you have admitted during search and it's a voluntary disclosure, because you generally have one particular question they ask, do you have anything to say? Is it voluntary in nature? And the assessee in most cases would have said, yes, I have nothing more to say. The statement is being given voluntarily. There is no coercion, undue influence, so on and so forth. But does by itself give a right to say that the statement was recorded without pressure? Can you rebut it tomorrow saying that why it was given under pressure, though you have signed that that statement was voluntary? It leads to a situation of, again, right to sleep. Because we are aware as to when a search process begins, say early in the morning, it can continue late in the night or till the early hours. So whether an assessee can claim right to sleep as a fundamental right, stating that you come to my house, you are searching, but this is my time to take a nap. Not probably in the afternoon hours, this afternoon siesta you can challenge it, but whether right to sleep is a fundamental right. Can an assessee take this shelter of right to sleep? Because if you look at a non-income tax case, in the Ram Leela Maidan case which came up involving Baba Ramdev, the Supreme Court there said that you could not have disturbed the petitioners in a particular case because right to sleep is a fundamental right, and if you had to arrest them, you should have done it the next day morning, and not, you should not have disturbed, which means in a different context, the court somewhere said that right to sleep will come into one of the fundamental rights. So we can definitely say that any statement recorded during odd hours, you may take a position, I'm not saying that this is sacrosanct, take a position that you are not in the best of the frame of mind to give that particular statement because the search has commenced at, say, morning 6 a.m. and has gone on till early hours of the next day, say 4 a.m., that you are mentally not in a position to give a statement, and therefore that you are rebutting that particular, retracting that statement. Now, when we use the term retraction, you also have to understand to what extent the admission stands on a tougher footing. Supreme Court in State of Kerala versus Pullangode Rubber Produce Company, 91 ITR, page 18, at page number 20, Supreme Court says that admission is an extremely important piece of evidence, but it is for the assessee who makes a statement to prove that the statement is not true, which means if you're able to prove with evidences and documentary submissions that the statement given by you during search was on a mistaken notion of law, facts, or both, and then that admission is not sacrosanct. But when it comes to retraction, there are two sublines in retraction, I say. One is a direct retraction, and one, I would say, is a deemed retraction. What is a direct retraction? You have given a statement agreeing to undisclosed income, then you would retract the statement, stating that for whatever reasons you would feel that you have ascribed to it, the statement given by you on oath under 132(4), you're retracting it and that you no longer stand by it. Earlier done the better, so that it indicates that it is not an afterthought in you retracting the statement. So what is the reasonable timelines that you have to do? Should you do it next day, next week, next month? Different situations will arise as to on what basis you are retracting the statement. If the statement was given based on your understanding of a particular position of law, which you find out subsequently that position was not wrong, you can explain it. If you have given a statement that you agreed to 10 crores as capital gains, but you later find out from the documents that the position was not either taken or handed over, depending on how you have offered the capital gains, you can prove with documentary evidence. So reasonableness will be the hallmark there. What is reasonable will depend on facts and circumstances of each case. But this concept of deemed retraction, this is nowhere mentioned in the Act. But what is a deemed retraction? You have made a statement, you have admitted during the course of search, you have not specifically retracted by way of another statement, and the assessment proceedings begin. The block assessment proceedings for searches conducted after 1/9/2024, or the proceedings under 153A to D for searches before 1/9/2024 begin. and you will be asked to file a return of income. Under the new regime of block assessment, which earlier existed from 1995 to 2003, which has come back in a new avatar, you will file a block return, whereas for searches before 1/9/2024, you will file separate returns. Now, during this time frame of you having made an admission for undisclosed income and not specifically making a retraction thereafter, at the time of filing of the return of income, if you choose not to include the income that you earlier offered voluntarily or in a statement on oath, by filing a return of income during the assessment proceedings for search, when you don't include that income, it amounts to deemed retraction, because by action you have retracted your statement. You have not given a statement specifically stating that you're retracting your earlier admission, but by action you have proven to the department that you do not stand by your earlier statement, because while filing the return you have chosen not to include that particular amount which you had offered earlier for taxation. So what happens here? Once you have given this statement and later on do not include it in the return, again the assessing officer will have to necessarily look into the evidence before him as to what led to the admission and on what basis you have retracted. To the extent you are able to convince the assessing officer with facts and figures that the admission was on erroneous interpretation or understanding of facts or law, you will be able to offer they will proceed with the regular ones. But practically, which may not happen, they will make the additions insofar as what you have declared, and subsequently you have to fight that in the appellate proceedings. But considering that this admission and retraction will be on one aspect, you have to look into one newer aspect which has come in now with respect to the powers during search, more specifically dealing with the powers of the officers during search of breaking open your almirahs, because under 132(1) clause 1, the officers have the power to enter and search any building, place, vessel, vehicle or aircraft where he has reason to suspect that books of accounts, documents, money, bullion or valuable article are kept. Also, they have the power to break open the lock of any door, locker, etc. or almirah also. If you look at how this has been brought about in the new Income Tax Act 2025 in section 247, it speaks about entering your premises, building, vessel, aircraft, where books of accounts or other documents or such information in electronic form or on a computer system are kept. So they specifically included electronic form or computer system in 247. And in section 261 of the new Income Tax Act, they've defined computer system to say to include virtual digital space. So therefore, the provisions of search and seizure concerning the treatment of computer system without mention of virtual digital space will also apply to that, because 261E defines computer space to include virtual digital space. You also have an important facet they have brought in to say, break open the lock of any door, which is possible physically, locker, safe, almirah, or override the access code to any computer system for exercising the powers conferred by clause 1, which means you're talking about granting them or them taking permission to access your digital space. Because if you look at the statement of the finance minister recently, the finance minister spoke about how the searches conducted based on information collated from various online portals such as Instagram, Facebook and other things led to undisclosed income of more than 500 crores, which means how people are flaunting their wealth in their online avatars, but when it came to the filing of returns and disclosure under the law, it was not being done. So this leads to a situation of how do they take that overriding the access? Breaking open the lock we can understand, but this also would involve now engaging of experts, which the law has given the permission to. They can engage the experts to, I would not say hack, but enter into your system through means, because they have been given the powers under the Income Tax Act to ingress upon your place, also ingress upon your computer system. Now, at this point in time is when the challenge of right to privacy and data privacy kicks in. Till such time when they come to your premises and are verifying your documents is on one particular leg. But when they get onto your virtual digital space and your online avatars, the right to privacy and data privacy kicks in. And how do you now say that what is the right to privacy and what are the ingredients that the right to privacy must fulfill? It must be a law in existence that authorizes the restriction, so the government has to bring in a regulation. The restriction should serve a legitimate or worthy purpose for which the state seeks to achieve, that unearthing undisclosed income. And it must have a rational nexus to the objects being pursued, which means for unearthing the undisclosed income, finding out the income that ought to be taxed. This comes in coupled with how the present law of data privacy is now there in terms of the Digital Privacy, the Digital Personal Data Protection Act, how the law has been given the powers as to what they can do and what they cannot do. Because once you're talking about data privacy, we need to understand how world over this has come over. Before we get on to our Indian system, the Digital Data Protection Act 2023, for which the rules are yet to be notified. The draft rules have come in, but the final rules are yet to come in. But I would definitely say this has taken a leaf from how the European Union brought about their first one, the General Data Protection Regulation in 2018. And you also have US having its own particular thing. China had issues with the Personal Information of Protection Law. Japan brought about the Protection of Personal Information. South Korea, for that matter, had the Personal Information Protection Act. Australia has a Privacy Act 1988. So globally, you have countries which have already latched on to the data privacy and how the data must be protected. And even in terms of the Digital Personal Data Protection Act, the law here gives permission specifically under Section 7 to say a data fiduciary may process personal data for any of the following, which will include for national security by way of a court order. For example, when they talk about fulfilling any obligation under the law for the time being in force on any person to disclose any information to the state or its instrumentalities subject to such processing being in accordance with the provisions regarding disclosure of such information in any other law for the time being in force, which means there is a fiduciary capacity that the data will be collected, how it will be processed. But specifically when we talk about the invasion of privacy and how it will impact Section 132, and during a search proceeding, we have to look into the documents that the department rely upon. What necessarily happens, they seize your computer, they seize your mobile phone, because today your mobile contains probably more information than your computer or other systems. Your books of accounts may depict one picture, but the information that your mobile may possess may be vast compared to the information that they can gather from other physical sources. Once they clone this particular device, which powers they have got, once they clone, we are supposed to have that particular statement by them. If it is not done in accordance with the law, dealing with, if you look at the Evidence Act of 65B, in the Sakshya Samhita it is Section 63. Without a statement from them or a hash value being given under 65B of the Evidence Act or 63 of the Sakshya Samhita, that particular information cannot be used against you, because you can always say that they have tampered with it because they have not given you a certificate in the prescribed format that the data was cloned in a particular way and for that particular way only, because it's a standard procedure that when a statute requires a particular thing to be done, it has to be done in that particular way and in that particular way alone. Therefore, the law cannot do more than what it has got the powers under. Therefore, we have to be very extremely careful when we look at the data in the mobile phones. Because I'm given to understand that when department clones the data, it results in a situation of the information of third parties being available to them. For example, if there's a raid on a chartered accountant or advocate's premises for a specific reason, his computer will have data pertaining to hundreds of his clients. Whereas the search might have been necessitated due to a reasoning for one of the clients of his. Therefore, when the matter went up in Bartley Boy's case, the Supreme Court said only the data pertaining to the specific client for whose information they had come to the chartered accountant's premises had to be looked into. That was how the courts looked at insofar as the collection of data is concerned. Can they use the data subsequently? That has to be in accordance with the law already laid down, and it cannot be based on whims and fancies of the officers. Now, once that search is completed, the admission and retraction, assuming you have not retracted, it goes on. It gets to the stage of the assessment. Before we get on to that, what happens in case of your breach of privacy? What is your right? Can you approach the courts? Can you file petitions? You will have, of course, but under the Information Technology Act, you can seek for compensation under 43A, which will be replaced by the Digital Data Protection Act now, because that is being given overriding effect on that. But the board may not really address cases of physical trespass, general illegal searches, or non-digital data privacy breaches. Because the Data Protection Act seeks to only protect you from the data which was digitally made available if the breach of it and not otherwise. Because when I was speaking to some of the experts on data laws, they said, if you have ascribed or permitted the use of your mobile number in a departmental store, there has to be a reason as to why they process it. And recently the guidelines also from the government are, the data has to be deleted if you don't give express consent. Similarly, when you hop onto some websites, certain boxes are ticked beforehand, saying that you're agreeing or you're giving consent for a particular promotional mail from them or processing of your personal data from your end. So which they want to alter it to say that unless you specifically tick that, they cannot take it as a consent. These changes will come as we get close to the rules being framed for the data protection. Now, once after the search has happened and the documents have been seized, you have something called a Panchanama where you will have, they will record in that what has been seized, what has been found, what has been seized, or found and seized. And in the Panchanama, which is a charter, it will also depict who authorized the search, which officers came to search you, at what time the search commenced and what time it concluded. There, it leads to an important facet wherein, can we say you can temporarily conclude the search? You start, say, morning 8 a.m., you conclude it by way of a Panchanama saying you've temporarily concluded at 11 p.m. and then you commence at next day morning. There are divergent views on that. Karnataka High Court in Ramareddy's case stated that a search warrant is not a season's pass. It's a one-way ticket. They said that you enter a premises, you have to finish the search and come out. You cannot keep going in and out of the premises as and when you want. But there's also a concept of clamping of a prohibitory order, wherein the department feels that certain things are impracticable to seize or verify in that for an almirah or a safe, they will clamp a prohibitory order on that, wherein you will not be allowed to open that and the department would later come back. At which point in time the question arises, what are the powers of the department or the officials then? Can they search your entire premises again? The answer is no. If the PO has been clamped on a particular almirah or safe or a particular room, they can enter only that room. All that you have to provide is easementary rights to enter into that room. You cannot say, I will not let them into the living room so that they have to enter the bedroom of which has been on a PO. But you have to give easementary rights to them to enter the place on which the PO has been clamped, and then they have to complete the formalities there. They cannot again search your entire premises when they come for the opening of the PO. Once that procedure is completed, the temporary conclusion or final conclusion of the search, there are divergent views, as I said, saying that in certain cases they said we have voluntarily stopped the action, permitted the assessee to take rest or rest for the night and recommence the operation next day morning, so that we cannot claim that I gave a statement in middle of the night and therefore I was not in a sound state. So therefore you may have divergent views there. But once that process of seizure is complete, the information is given to the jurisdictional assessing officer for conducting an assessment. And now, for searches conducted after 1/9/2024, we have gone back to the old regime. You had something called a block regime, which existed from 1995 to 2003, in Chapter 14B. Thereafter, from 2003 to 21, you had under 153A to 153D governing the search provisions, assessment for search provisions. Then for a brief period, they went back to the 148, and the assessments for search also were under the 148 and 148A regime. And from 1/9/2024, they have gone back to the block assessment regime, wherein under 158BA, it starts with 158B, which contains the definitions. 158BA talks about abatement of all pending assessments. 158BC is when we talk about the notice to file the return of income and procedure for assessment, determination of total undisclosed income under 158BB, and levy of interest and penalty. But what is this block period? In the present context, in the 1995 law, you had first for 10 years, then they brought it down to 6 years in 2001. And now, under 158B, the block period means the period comprising previous years relevant to 6 assessment years during the previous year in which the search was initiated or requisition made, and also includes the period starting from first day of April of the previous year, in which means, for example, if the search was commencing on, say, 28th March 2025, it is financial year 24-25. So you go back to 6 previous years. Though in the new Income Tax Act they use the word tax year, we use the word previous year here. It goes back to 6 previous years, that is, previous year 18-19 to previous year 23-24 comprise 6 previous years, and this truncated assessment year from 1/4/2024 to 28th March 2025, if the block period existed in the old regime, that is 95-2003. But in the present regime, it extends beyond that, the truncated assessment year, till such time the search is completed. For example, if you take that the search is completed on 30th June, how do you say it is upon the date of execution of the last of the authorizations? Which means, now we go back. We spoke about authorization, who are authorized. When we speak about the execution of the last of the authorizations, say on 28th March when they have conducted the search, the authorization dated, say, 25th March might have been given for a particular premises, 25th March for premises 2, on 28th March for premises 3. There were issues concerning as to which is the last authorization executed. Should it be the last authorization given to be executed, or which is executed? Now they speak about, they have also defined in the present law, in the present regime, as to what is the last of the authorizations to be executed. So considering the example we're continuing, assuming that the last of the authorizations gets over on 30th June, you will have the period of search from 1/4/2018 till 31/3/24, that is 6 years, 1/4/24 to 28th March 25, extending up to 30th June, which means the last truncated period can be and will be for a period of more than 12 months. That will be construed as the block period. And now once you have the block period established, the procedure that necessarily follows for that is how the assessment would be completed in accordance with the provisions here, the block return and how the income has to be assessed. But more so, if you look at from how the block assessment has been designed, you have the person searched and the other person also. Because in a search concerning, say, person X, documents pertaining or belonging to Y can be found, and based on which the department will have a right to enter the other person's premises. So you have different block periods for a person searched and for the other person under 158 BD. So therefore, when we look at the procedure for block assessment under 158 BC, it speaks about the, after search has been initiated, the officer shall, in respect of search initiated, issue a notice requiring you to furnish the return of income in the form and manner but wherein you are supposed to bring out your undisclosed income. There is an amendment in Finance Act 2025. There was an anomaly when it was introduced by Finance Act 2024, wherein the computation mechanism provided in the Finance Act number 2 2024 had led to a situation where even the income disclosed earlier prior to search, which was taxed at regular rates, could have been considered as undisclosed income based on the computation mechanism given in the Finance Act 24. That anomaly was addressed in the Finance Act 2025, wherein only the undisclosed income will be brought to tax, that is undisclosed income offered, if any, by the assessee, and then any additions made to it by the assessing officer while determining the undisclosed income. Under 158 BC3, you have an important facet of the assessing officer, before issuance of a notice to requiring you to furnish the return of income, shall take prior approval of the additional commissioner or additional director or joint. What does this mean? The emphasis here is on prior approval of the higher authority, because it is settled position of law that the wisdom of the lower authorities must yield to the wisdom of the higher authorities. Therefore, the emphasis is here in before issuance of notice itself, he has to take prior approval. In contrasting that with the 153A to 153D regime, wherein for issuance of notice under 153A, there was no prior approval required. But for framing of assessment under 153D, the approval by the Joint Commissioner was mandatory. Only after the approval by the Joint Commissioner under 153D that the officer could have passed an order under 153A or 153C. Now you have more emphasis at the time before issuance of notice itself, the AO has to seek prior approval of the additional commissioner. This leads to a situation where whether the AO has to give reasons as to why he is seeking approval. Can that reasons be questioned by us? Because if we look at how approvals have been passed in Boyka, Prime Chemicals, where they said approvals given in a mechanical manner without application of mind has no legs to stand the test of law. Similarly, once a law presupposes application of mind by higher authority, you have to presume that the higher authority has applied his mind before granting his permission, and such a permission is always amenable to challenge, is one thing. And you also have to look at how the block period will be defined for the other person. You may have two specified persons who are searched, and you may have a common person, records which are being found there. So the block period for the other person would be reckoned from the last of the searches conducted on the original person. That is, if I am a person searched and assuming Sachin is also a person searched, and the other person, say, the chairman, for the other person, for his timeline, which belongs to as to the last of the searches or the later date will be construed as limitation for him. So therefore, the law of limitation also works differently in terms of search cases compared to the regular proceedings. And when we talk about Finance Act 2025, they also brought in virtual digital asset to the list of assets under undisclosed income. There was a small lacuna in the Finance Act 2024 wherein virtual digital assets did not find place in the definition of undisclosed income. Even that has been brought about now. Considering the fact that this topic would take probably a day to finish, and considering that Sachin also will dwell on data privacy and other issues concerning block assessment, I would stop my presentation here. Thank you for a very patient hearing. The other facets, Sachin would take it forward, and Nagin sir would give his concluding remarks thereafter. Thank you. Thank you for a patient hearing.